Go ahead.
All right, thank you. The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Good morning. Welcome to the September 9th, 2022 sitting of the Appeals Court. I'm Justice Shin. With me are Justices Hand and Brennan. We're going to be hearing two cases on the Zoom platform today. The first is Commonwealth versus Green, number 2020 P317. And Attorney Lindmark, you are first.
Great. Good morning, Your Honors. May it please the court, I am Attorney Lindmark, and I'm here arguing on behalf of Mr. Green. In this appeal from a probation revocation, it's our position that probation was improperly extended for a period of more than 4 years without his acquiescence and in violation of his due process rights. The 4 years and 2 months, technically, I believe, delay was unreasonable, specific prejudice resulted, and as a result, the court lacked jurisdiction to revoke Mr. Green's probation.
Attorney Lindmark, could I interrupt you and ask this? I'm not clear on your client's position that the probation was extended for that 4-year period. I'm very clear on the delay between the notice of violation and the resolution of the surrender hearing, but the argument that the probation was extended during that time, where's the support for that?
Well, the timeline in this case is that he was released from jail in 2013 with his 5-year probationary term already underway. It was scheduled to end in 2016. He appeared on new charges in 2015 and was taken into custody and held to this day after that. The probation revocation hearing was not held until 2019. So it would be my understanding, and you can correct me if I'm inaccurate about this, that his probation therefore was extended until the time of that final hearing.
So maybe a semantics issue, but am I understanding correctly that the point is because it wasn't terminated on the scheduled end date, that's the extension that you're talking about, not a permanent extension of some kind?
Yes.
Okay, thank you.
That was my understanding.
Counsel, is it your understanding, following that up, that then he would have been subject to further violations over the course of the 4 years that the probation violation was pending? Or do you understand my question? If you understand it, just
he was taken into, it was pending,
Right.
is my understanding, because of the new charges that were levied against him.
But you'll agree that if, for example, there was a further violation in year 3 into that, he could not be violated for those new acts. Is that correct?
So if while he was waiting for this hearing,
Yep.
he then somehow brought on new criminal charges, and could he again be violated? Well, they could, I would think they could, this is all hypothetical, I would think they could serve him, surrender him for, well, it's our position that his probation should have terminated. So our answer would be no. Probation department might argue otherwise, as they did with this case.
Thank you.
Could I ask one more question, since I've already interrupted your flow to begin?
Well, that's fine. That's fine.
Frequently. Was your client held on the new charges from the March date on which he was detained also on the probation matter? When he was arraigned in March, was he also held on bail from that point forward?
No, it's my understanding that he continued to be held as a result of the warrant being served on the probation violation.
But there wasn't also a bail on the new matter?
I'm not totally clear on that. I apologize, Your Honor, but I do not believe there was. And I know that at the time that he reported to probation and was taken into custody, he had been living at home with his fiance and child and no issues, and had been reporting regularly. So I can't imagine that they would have requested bail.
But was he well, the new charges were serious ones. So we'll put it.
They were serious.
Would have been the date your client walked in March was both his arraignment date, is that correct? on the new charges as well as the date on which he was detained?
I have the timeline here. He did go into probation. It's my understanding he went into probation on one day and the next morning he was brought to court. They took him into custody and the next morning he was brought into court.
Okay. If he had been held on bail during the time that he was also being detained, I guess that's my question, is if he was held on bail while he was also being detained, would that have changed your argument here about the loss of liberty occasioned by the probation surrender?
If he was held on bail on the new charges, then that might affect the analysis, and that there are cases saying if the loss of liberty is due to another case or another conviction, then it would affect it. And it could turn out otherwise, but we're arguing that's not the case. And in fact, his due process rights were violated, if you understand.
I do. And thank you for letting me ask that question up front.
Oh, my pleasure. The Commonwealth here is arguing, I believe one of their arguments is that it's due to Mr. Green's own actions that he was, that brought on this delay. And so it was not an unreasonable period of time for him to be held. Those actions would be the alleged continued request for continuances. He was not responsible for the number of continuances granted by the court. And in fact, he often was not advised of these continuances until after they took place by his counsel, and also often was not even brought into court when they transpired. A close reading of the docket entries shows that there were many continuances, some at defense counsel's request, some due to court or even prison transport failures, and others were requests by the Commonwealth. By far, however, were joint requests with both parties agreeing to request a continuance.
Is that prejudicial then for those delays that were either requested by your client or jointly requested?
When they were jointly requested, it's our position that he should not be held solely responsible for those requests. And ultimately, though, even with all of these continuances, we're arguing that it was for the probation department and even the sitting judge to push for action and a final hearing. That did not happen in a timely way here. Mr. Green has. Oh,
go ahead.
I was just going to point out to the court that Mr. Green has been gravely prejudiced as a result. He's been held in custody ever since, hasn't seen his new baby in 7 years, his fiance, and has yet to be convicted on any charges as he's contesting the new charges and still waiting for a trial date.
Does your client dispute the fact that the probation dates appear to track the dates on the new case? And as the Commonwealth argues that there's an indication in the record that there was some discussion about global settlement or resolution, rather?
There was some discussion on that, but our position is, well, my client's position is that it was suggested to him initially by the court, and having been held for years, he felt that it was his right to at least hear what was being suggested for his future. I mean, ultimately, he refused to plea out even when some lesser sentence was proposed for him. And as I said, he's still waiting for trial, hopefully next month. So it's a fairly basic case, a basic analysis, and ultimately it was the court's responsibility to make a concentrated effort, as articulated in Sawicki, to resolve his status with reasonable promptness. That was not done. He's been held in custody ever since. And his due process rights, we would suggest, have been trampled on, and respectfully, we would ask for a reversal of this finding of revocation.
Well, in Odoardi, which is cited in your brief, the court notes that there could be good reason to delay a probation hearing pending disposition of new charges. It gives the defendant the time to clear himself of the new charges. So in light of that, and that many of these continuances were at either joint request or the defendant's request, I mean, how are we to assess your claim that the court or the probation department should have moved more promptly?
Well, there were quite a few continuances, as I stated previously, and again, we're suggesting the joint requests are the majority of them. And we know that it's common practice in court for if one side is seeking a continuance, often they'll ask the other side, will you assent to this? And they do that kind of out of respect for co-counsel. And it's hard to judge with joint requests who actually is responsible for those. The bottom line, however, is that the probation department and even the sitting judge should push for action in a final hearing, which I think Judge Reardon did at the end. And the case was pushed to a final hearing and he did revoke his probation.
Even where the defendant himself is asking, or the probationer is asking for the continuances.
I'm sorry, I missed the first part of that, excuse me.
Even where the probationer himself is asking for the continuances, the court is supposed to essentially just push the hearing forward against the defendant's wishes.
It's always been my experience in court that judges reach a point in time where they're not going to grant any more continuances, no matter who's requesting them. And we would suggest that it was their responsibility before 4 years and 2 months had passed to make that determination. And that would be, I would rest on my brief.
Okay, thank you.
Thank you.
Attorney Yanishevsky.
Good morning, and may it please the court. Andrei Yanishevsky for the Commonwealth, asking this court to affirm the order denying the defendant's motion to dismiss the probation revocation proceedings. If I may just start with a couple of clarifications in my brief. Page 7, the word supra should read infra, and 7, 11, and 13 of the Commonwealth's brief refers to pages in the Commonwealth's record appendix that are actually part 2 of the appendix. When I went to submit the appendix, I had to split it into 2 for size reasons. So any references in the appendix to 104, 105, and 110 to 114 are actually Commonwealth's appendix 2, 8, 9, and 14 to 18. So I do apologize to the court for that confusion. Here, Judge Reardon was within his discretion in denying the defendant's motion to dismiss. The court had jurisdiction. Judge Hand, I want to answer your question. In Judge Reardon's decision, footnote 1, he notes that the defendant has been held continuously detained on the 2015 shooting charges through present. That's footnote 1 of Judge Reardon's decision. Of course, probation can be revoked after the expiration of the probationary period within a reasonable time. There's no prejudicial delay if the defendant is responsible for or seeks benefit from the delays. As the court noted, and as I noted in my brief, there were, by my count and by Judge Reardon's count, 41 probation revocation hearing dates in this matter. At least 25 by my count were extended at the defendant's request or the joint request of the parties. And that tracks with Judge Reardon's finding that the defendant was attempting a global resolution of the 2 matters. And that's evidence for that in the record is in the second part of the Commonwealth's record appendix 8, 9, and 14 to 18. So there are cases that talk about the needing to show specific prejudice to the defendant, but there is no specific prejudice to the defendant where he acquiesces in these extensions and seeks to benefit from them by attempting to resolve both matters together. He was sentenced on the armed assault in a dwelling on the probation violation, and that was a 10-year mandatory minimum sentence, and that's how the 10-year sentence got handed down on the probation violation. But I would also note that the court was reasonably prompt in trying to effectuate the violation hearing. Indeed, Judge Reardon found, oh, I'm sorry, Your Honor. Did you ever? No, I'm sorry. Indeed, Judge Reardon found that on May 26, 2015 was the first date that the hearing was scheduled. So that was just 2 months after the BOP warrant issued in March of 2015. And the dates were subsequently pushed back numerous times, 7 in 2015, and then 9 and 11, and they're set forth in Judge Reardon's decision, and those are definitely supported by the record. I would also note that prior to May of 2019, when the defendant was found in violation, he had twice sought to dismiss the 2015 shooting charges. So that's going to contribute to the delays here. In addition, the defendant was represented by 3 different attorneys in 2017 alone, ostensibly adding to the delay. And because these findings are in the record, they're supported. Judge Reardon made them, and they are supported. And there is case law that says, as long as the findings are supported, that's Commonwealth versus Morse, cited in my brief, and the record discloses sufficient reliable evidence to warrant the findings by the judge. I would suggest this court should affirm. I would also note, just on some of the cases of reasonable delay, the defendant tries to distinguish cases where the defendant or the probationer is outside the Commonwealth or outside of the jurisdiction. None of those cases say that's the only way to have a reasonable delay. There aren't many published opinions in this area, and they tend to be under that sort of fact pattern, but certainly not the only way, and the cases don't stand to that proposition. In fact, they're fact-specific inquiries, and that's what how the cases say. So if there are no further questions, I would rest on my brief.
Counsel, thank you both. The case is submitted. Hold on one second.
The case is now being recorded.
Okay. The next case on our list is Commonwealth versus Mejia, case number 2019 Key 1840. Attorney Horowitz.
May it please the court, Dan Horowitz for Mr. Sylvan Mejia. I will naturally start with the first issue, which involves 2 related requirements that apply to the Commonwealth in cross-examination, or in this case, the prosecutor must have a good faith basis for questions asked. This can be apparent in the record, or it must at least be ready to satisfy the judge that there is a good factual basis for the questioning. But even if there is a good faith basis, they are not to persist in questioning in the face of consistent denials. Specifically and primarily, this issue concerns a series of questions, several series of questions that appeared to assume the fact that Mr. Mejia had either molested his son, pulled his son's pants down when drinking and didn't remember, or might have molested other children at parties, might have pulled down people's pants, and the like. Now, to this, the Commonwealth in its brief says the good faith basis is actually the family's testimony about his physical immobility in the past when his alcohol interacted with his medications, and that she wasn't expecting a positive answer. She wanted to elicit negative answers because she wanted to contrast this with testimony about his mobility at the party. To this, I say rhetorically, why use questions about child molestation for that? Why ask questions if the goal is to show past immobility that even risk implanting in the jurors' minds the idea that Mr. Mejia might have molested his son, and the prosecutor knows it, but they don't. She could have asked about if that was the goal, it would have been much less dangerous to ask questions about any other sort of physical activity.
I see the goal as broader, which is to establish that his behavior on the night in question was very different from any sort of behavior he engaged in the past. So, I mean, that was the defense. It was very clear that that was the theory of the defense. So why doesn't that make this line of questioning proper?
Well, because Well, the problem is the effect on the jury. Well, I don't say probable, the possible effect on the jury. Questions that are likely to inflame or degrade, like those, should not be asked in the face of consistent denials. It's because the jury doesn't necessarily know what's in the prosecutor's mind and heart. When they hear a prosecutor repeatedly ask the question, "Did you pull down your son's pants?" No. "Did you straddle your son?" No. Well, how do you know that? This repeated several times and it was a brief cross-examination. When they hear that, there is a risk that they conclude that the prosecutor knows more that they don't. And on the other end of things, in closing argument, the prosecutor didn't refer back to these questions. Now, I'm not suggesting she had a duty to, but the point is, in closing, she did contrast the family's testimony about how he was immobile when he passed out with what the Commonwealth witnesses testified he did at the party. But that shows that the questions about, did you molest your son? Did you pull down other children's pants? That those were completely unnecessary for this purpose. And the danger is particularly acute here because this is a case, it alleges child sexual assault. And I think I would suggest that's one of the most heinous crimes a person can commit, can be charged with. And so questions that could be read as implying that he has molested other people in the past, other children. I'll put it this way: if that evidence if there was evidence of that elicited from any other witness, cases like McClendon show it would be a clear path to reversal because it's the exact crime he's charged with. And again, there are so many other types of physical actions that she could have probed about. Well, are you able to do this? Were you ever able to do that? Were you able to go up and down stairs? Were you able to speak to people? And it could have repeated that with a family and gotten this exact same contrast as the Commonwealth states she was going for with the questions about molesting his son and other children and the like. And the prejudicial effect of that is to risk disgusting the jury with him. And
isn't the implication that the jury would have drawn from these questions is that they're designed to elicit a negative response, right? There's no implication embedded in the questions that the prosecutor believes that he in fact did assault children on these prior occasions. Wouldn't that be obvious to the jury, the purpose of these questions?
I don't know that it would. Again, they weren't referred to by the prosecutor again after being asked. The jury was just kind of left with the idea hanging there. And again, it's not so much that the implication has to be directly built into the question. Part of the problem with persistent questioning in the face of consistent denials is that basically the prosecutor, in persisting despite no answers, it conveys a sort of sense that the prosecutor is confident that this is true. Even
counsel, could it not also convey the idea that, of course, it's not true, in contrast to what we have here?
But then why use child molestation specifically and risk it? There was the family themselves put in the defense through the family put in evidence that he was immobile in past black and pass out periods, if I can call them that. So there just was no need to build on it. And the case law is clear. You should not persist as a prosecutor in questioning despite consistent denials.
So the jury acquitted on one charge, right?
Yes.
So, on review for a substantial risk of a miscarriage of justice, why do we not take that as an indication that the jury assessed the evidence and they were not prejudiced against the
One specifically, it comes down to what they had defined. It is true that assault with intent to rape is a specific intent crime, but indecent assault and battery is a general intent crime. And I assume you are asking about, well, doesn't that show they were able to distinguish this specific and general intent? I think it's the specific facts that they had defined actually make the split verdict a bit odd, and it makes it look more like a possible compromise verdict because in order to convict of indecent assault and battery, the only act that the jury was to judge was the intentional taking of his penis and touching it to AR's buttocks. And there was testimony that his own pants were down, he'd pulled down AR's pants and AR's underwear. Now, that kind of incidental contact, just as a practical matter, is what one would naturally expect to precede an attempted rape. It's not something, for example, in a hypothetical case, let's take a stereotypical stranger assault. Someone enters a stairwell, the victim enters a stairwell, someone jumps out and starts grabbing them. Maybe it's a woman, they grab their breast, their buttocks, the like. This goes on for a few minutes, there's an interruption, and the attacker stops. Now, in that case, it would make a lot of sense for the jury to acquit of assault with intent to rape, because none of the actions are actually, in this hypothetical, the attacker didn't try to take off any clothing, didn't do anything beyond the molestation. So it would make sense for a jury to say, okay, well, we don't find this intent to rape, so we're going to acquit of assault with intent to rape, but we find indecent assault and battery. Here, what Mejia is alleged to have done is exactly what you would expect someone who also had an assault with intent to rape to do.
Attorney Horowitz, can I ask you just one question? Circling back to your argument relating to repeated denials.
Yep.
Are you aware of any case that discusses repeated denials that is not in the context of the crime charged? Because typically you say, oh, you committed the crime. No, I didn't. Oh, yes, you did. You did, didn't you? No, I didn't. Oh, you were there on that day. No, I wasn't. Yes, you were, weren't you? Yes, I know. That seems to me to be the case law. It's on the crime charge, not some other extraneous or side. Do you know of any other cases that parallel the type of questioning here that you suggest falls under that category?
Well, I believe a somewhat similar question. Shame on me, I forgot the exact crime charge, but in Murphy, the question, how did it feel when you were sucking on your son's penis? Now, that's not exactly the same, but the court there made
which the defendant was charged.
Right. Well, it was a sexual assault crime, right? And the court made the point, look, this is incredibly likely to inflame or degrade. And where that's the case, you should not, the prosecutor should not ask those questions. It was irrelevant there in a similar way that it's irrelevant here, in that it doesn't so much matter that specifically that Mejia did not molest children in past when he was drunk. What matters is he was either completely unconscious and unable to move, or he could be woken up but still had to be carried. And again, that can be put in evidence any number of ways.
Your argument isn't that it's irrelevant. Your argument is that it should have been presented, that particular type of evidence should have been presented in a different way. Is that correct? Right.
I mean, right. No, you're right. The evidence, it's a legitimate purpose to contrast past immobility with what was alleged to happen at the party. It's just that those questions were a live wire. And if that evidence, if evidence along those lines came in from anyone else that he actually had, that would be a clear path to reversal, like in McClendon. But they didn't. Instead, the idea was possibly planted through the questioning. And the effect of this kind of dovetails. The other second major part of the first issue is questions that are likely to elicit sympathy. Now, the Commonwealth says these are admissible to rebut recent fabrication, a claim of recent fabrication, and they seem to primarily rely on Espinal. The word choice is important. Fabrication is an intentional act. It's an intentional falsehood. Someone is making something up. There was no charge of fabrication in this case. The defense was honest mistaken belief. First, on Wesley's part as to what she thought she saw when she walked into a room, turned on the light, and saw an adult with their buttocks out lying right next to a child. She made the natural assumption, is the defense. And then that child, when he wakes up and hears Wesley and then later other trusted adults screaming and yelling about what they thought they saw, may have formed a false memory retroactively as he's coming out of consciousness. I suggest the need is not the same as in cases where the defense would have been, oh, he's making it up. Because when the charge is someone's making it up, it's only natural to ask, okay, well, did they act like what they were saying now was true back at the time they said it happened? But there was no argument or even implication, nothing from opening that the jury could possibly conclude that the defense was that AR just made this up with his parents, or that the parents made it up for some reason. And when that's the case, the need for the evidence is much lower. There isn't that relevant purpose of showing that they acted the way they would act if they believed what they were saying. And that just creates a greater danger, again, that the jury might get pulled over the line and convict where they otherwise wouldn't. I can't tell you where the line is. The case law certainly doesn't and could not provide a clear line, but this was too much. And I just want to, in the very little time remaining, clarify a few points about the misstatements of evidence. The problem with the statement to the jury about how Mejia's status quo was being functional despite drinking, mixing medications, and marijuana. That is not a fair inference from the evidence. He did agree that it was a status quo at that time that he drank a lot, up to 12 beers a day. And he did agree that for a period around then, and until he got found on the side of the road by the fire department, he didn't know that the medication was interacting with alcohol. You cannot fairly read into that, though, that the reason he didn't know is that he was functional and not passing out. The testimony on this was he passed out when he mixed his medication with alcohol. And my time is up. So thank you very much.
Any other questions from the panel?
No.
Okay. Attorney Doherty.
Thank you, Your Honor. May it please the court, Andrew Doherty for the Commonwealth. Watching over the YouTube channel is Assistant District Attorney Alyssa Goldhaber, who was the trial attorney in this case. I'm asking that the court affirm the defendant's conviction and just standing by my argument with respect to the prosecutor's intent to that it wasn't made in bad faith, this cross-examination of the defendant and witnesses. But one of the ways that I think the court can think about this is that if ADA Goldhaber had asked the questions and elicited a yes answer, would we be here, right? Or would we be making this argument? So if the prosecutor had said, when you passed out at this party, you didn't pass out at this, so that you would, you didn't pass out that night next to a child. Correct, I did not pass out next to a child. And so I think the fact that he is denying it is the, I'm sorry, Justice Brennan.
Yeah, no, so Attorney Doherty, let me just, and respectfully understanding there's a trial dynamic that we're not feeling here. You'll agree that if the answer is yes, that's not a good thing.
No, but
because then the case is mostly reversed in about 3 seconds. So
correct.
Choice of theme on questions there.
No, but there's a way to ask these questions eliciting the same answer where he agrees that was not something that would happen, and all those other occasions where I blacked out drunk. Which just shows that the prosecutor, and so that's what I'm saying. If he had answered these ways, if the question were asked in a way where the witness said yes, that I did not pass out at that moment next to a child in all the other cases, I think we wouldn't be hinging this on this persistent denial as if it was an insinuation that in fact this was something that he regularly did. And one other thing I would just add is part of this analysis is a question of whether these questions were being asked in good faith. And I just can't see a trial strategy where it was so clearly that an attempt to distinguish the events of where the molestation occurred from all the other events that were testified to show the defendant's testimony was not credible about his level of intoxication at the time, and that this was the central issue of the case. I'm not sure where else to go here that isn't covered by my brief, and unless there are other questions, I would just add that my brother points out the fact that there was questions that elicited the victim's demeanor, talking about what his reaction was to it, and I don't read.
Before you move on to that, Attorney Doherty, I had a question. So some of the questions were phrased in terms of, have you ever been accused in the past of doing some of these things? Does the prosecutor need to know what the answer to that question is, or have a factual basis for that question before she asks it?
I'd say first, there was no factual basis for him to say, yes, I have been accused of that. So I think
right, but let's say he had been accused. I mean, so what is the response supposed to be from the defendant?
That's an interesting question. I mean, I would start by saying I think that question in itself is relevant, where his testimony is, I was blacked out and didn't recall any of the events that occurred. So I don't. So, but the fact that he doesn't then say, having woken up, having had no memory of what occurred the night before, I was not confronted with some accusation that I had done these things the way I am today. I think that's fair game. I suppose I could say my full expectation is that prosecutor would know what the defendant's criminal record was at the time that the question was asked, and was not anticipating an answer where he said
it was framed in terms of accusations, and it's a dangerous question in my view, because without knowing the answer to the question, had the answer been yes, I don't know if you'd be in the same position today.
I suppose I'd also say that according to the defendant and his mother and brother, he was immobile and utterly incapable of any intentional act when he was passed out, and taking that into account, and how firmly they stuck to the story that this was how blacked out he traditionally got. I don't think it is as. I appreciate the justice's comment. I don't know that it is as we may disagree about how risky that question is, but I take the justice's point. The only other thing I'm not sure I fleshed out entirely just why the fact that this was a birthday party was relevant, and not an improper appeal to sympathy, and the fact that it was a child's birthday party it is relevant to consider the defendant's state of intoxication and his testimony about his state of intoxication, but also explains the remarkability of the victim's response to being hugged in the kitchen, that he essentially left the party after that and was seated close to his mother because he was alarmed by this, and then his reaction to the sexual assault. And unless there's any other questions, I would otherwise just rest on my brief.
Any other questions?
No.
Thank you both. The case is
Thank you.
submitted.